Hey everybody, it's Sunday, I think September 3rd or 4th, one of those days. Happy Sunday. I wanted to do a video today on a very important topic, aspect that is only exists in the fourth crown of American common law, because our law is founded in theology, in the orthodoxy of Christianity, and the law that Yeshua brought in his hypostatic trinity is really what it is. So in that, the common law of America is different from the British common law, and this is how. And there is a great history that has been hidden from us, and I'm going to be talking about the most critical standing in our standing. This is where we stand in all claims in the fourth crown of American common law, and that's in Propria Persona. And you have to be in that standing in law, which they don't recognize, and I'll show you that they're supposed to, in order to affect, one, bring the demand that they settle the claims and complaints in the common law, and that you are bringing with it the crown that I'm speaking of in American common law, which is different than British common law. Because that in Chancery, which is Chancery, the British common law was still subject to what the king wanted to have done. And we don't believe in kings as men, big K kings, that our final judress, how would you say if it was female, is God, the creator of all. So I'm going to go real quickly, and I'm not going to do it quickly because I'm going to be moving between a variety of different resources. One are just some basic definitions that you can get on Wiki, and the other one is I'm going to talk from the Judicial Act of 1789. So I will introduce this particular standing in law in Propria Personam, and I will also be speaking about the American Admiralty, which is by Erastus Benedict, which he wrote particular how Admiralty law applies to our law, American Admiralty. So there's American Admiralty and British Admiralty. Okay, so we have particular forms of the fourth crown because we have created the persona. Okay, we are the persona, and when we are possessing spiritual enlightenment in the fourth crown. So I'm also going to bring Title 28 so that you are aware of where this comes from. Now, where the term in personam comes from is actually extensively discussed in American Admiralty. And there are two types. Now, let me just go through and read some basic things on that. The word in Propria Personam, in its simplest sense, means improper person. Okay, and so you're like impropriety persona, improper person, personam, person. Now, the word person is adorned, of course, in Admiralty, in their jurisdiction, in their commercial law. They now have it so that a person is a thing and a man, and that really isn't the way the common law works. There are rights of persons and rights of things, and they're trying to make it so that corporations are seen as material instruments and not subject to lien, so that you take the man out of the instrument. So the distinction between the all capital person and then the lowercase p person, the man, is that the uppercase person is an instrument. Okay, and it can be seized according to the 13th Amendment, their 13th Amendment, when that instrument, that person, commits a crime. So if it's a private instrument, let's say a bank, or a banking structure, or a court as a bank, sitting in a seat of government, the seat, the see, okay, the seat of the Pope, okay, Holy Roman See, that's the See, is the seat of law. And then the Pope as a man occupies that instrument. Now, it's the same for the all capital person of the court. Court is a corporate person. All capital dead thing. It's a corporation. So a corporation is the all capital person. Okay? But then there's the lowercase p, which is the man, the thing. And the distinction between that is really important. And you need to not let them adorn those, because that's what they're doing with you. Because you hold a seat of an instrument of law, and yet you are a man, a woman, in persona, in proper person. Now, in our construct, in their construct, in propria persona means in the proper person. For us, it means, I'll explain this to you, it's a mask, because a persona is from the old Greek terms of a mask. Okay, so this is from Wiki. Persona. Persona, personae, so, is the word's everyday usage, is a social role or a character played by an actor. Remember, that's all theater down there. It's not real court. Okay. The word is derived from Latin, which is originally referred to as theatrical mask. Okay. And it can also mean the legal attributes such as rights, powers, and duties following that role, the role. So your person that you come with in law is what defines your rights. So if you come in the standing in propria personam, you come in the right standing. You literally come with the rights. Okay. In theirs, they're removing the in personam jurisdiction from American Admiralty and only operating in rem, because they're supposed to do both. But when you're here, until you get to international law, you really are not afforded in personam. In fact, they act like it doesn't exist. Okay. And in doing that, they deny you as the living flesh. Okay. So it really is about them making you a thing in all respects, so that you can't invoke the standing of the living man and invoke our law, which they're subject to. So if you are not seen as a living man and seen as a thing, and I mean woman, okay, so woman has man in it, so let's always make that clear. If you are not able to come into the banking settlement as the living man who is the true executor of the surety and the beneficiary creditor and all these things, you then are a thing which can be abrogated and appointed a legal representative and made an estate. And this is the term, so we have the term persona, okay, and that is Greek, and it means the mask. So it's the mask and the rights, but extended in legal, it means the rights that you bring with it. So persona in law is not just you, but the rights you bring with it. Okay. So it also is very similar to another word, which is in Christendom, in prosopon. Now I may be mispronouncing these, and they try to say that they're often confused with person, because in prosopon it has to do with the hypostasis, the Trinity. Flesh, spirit, the Father, Son, and the Holy Ghost. But that's the Trinity. But there's the Trinity of hypostasis also in total spirit, total flesh, and the man who embodies spirit in flesh, the living flesh. Get it? Embodiment. So when you are in the Trinity of hypostatic union, you're like Christ. You are the living man, enlightened with the enlightened spirit in hypostasis. So the Trinity is all three of those: knowledge of the spirit, knowledge of the flesh, and embodying them in the flesh. The mind, body, spirit in the flesh, enlightened, living flesh. That is what they're trying to deny you by not allowing you the in personam jurisdiction, which is afforded to us by our law. Okay, so in theology, the term is mean the self-manifestation of an individual. Okay, you're not out there. It's about this right here, and that extends even further to this. It distinguishes things of self versus things foreign to you. So being that the word is truly defined to mean the essence of self. When you say, I'm in the proper person, I'm in the proper mask of self, okay? But it's a standing for all men, where you actually are representing all selves as an enlightened man, much just the same way Yeshua did. He represented all of us as our advocate. So when you go into one of these banking forums and you say, I'm in Propria Persona, you aren't just speaking for self, you are actually speaking for self-dom, all selves, all men, all women, just as Yeshua did, as an advocate for all men and all women in greater high law. Okay, so that is one of the basic atonements of just the word, where it's actually rooted in theology. Personae is a term of theology, but it's also in law. So that's where we are unique, because our law is rooted in theology, and so we get to walk in these areas. Okay, so the hypostatic union is important because I discussed it, but you need to kind of understand what hypostasis is. And again, this is from Wikipedia, easy to look up. These are also theology terms, okay? And Yeshua was deemed to be in the hypostatic union, possessing the Father, Son, the Holy Ghost, the substance, the flesh, and both together in enlightenment. So in the simple definition of hypostasis is the actual concrete existence in contrast to abstractions. So again, fictions are abstractions. Corporations are abstract constructs. Men are in hypostasis and of real substance. We are flesh. So we are when you walk in hypostasis, if you say, I'm in the Trinity of the hypostatic union, that means I'm the living flesh. That's what it means. So we are in hypostasis because we are of real material substance. They are not in hypostasis. They are in abstractions, things, incorporeal hereditaments, things not tangible. Okay? The spirit is kind of like that, but we consider the spirit kind of a material thing because we hold it within us. So it literally means substance. So when you say I am in the Trinity of the hypostatic union, it means I am the Father, Son, I am the substance of humanity, of the spirit and the flesh in divine combination. Okay, these are all like old theology terms, but they're also philosophy terms. These come from Aristotle. These are old. Before theology, these were just philosophical constructs. So, and the reason why theology and law are so closely related is because they all come from philosophy. So these are all terms that kind of work within each other in our law, just our law. I can't speak to Chancery or anything like that, but I can speak to the law that I know. And I do know that Chancery is totally different. Chancery, British common law, is totally different from ours because we are not subject to the edict of a king who can overrule any common law, anything in Britain. And if the king doesn't want it to happen, it doesn't happen. In our law, what the people want overrides, quote, kings, people appointed to represent us. So another word that's important, just because I want to put that out there, is, I probably pronounce it, it's Ousia. Ousia. It's Ousia. And that is an important term because it means primary substance, okay? And it literally is, this is another term kind of combined which speaks about, and this is even talks about, there's a quote in here from Wikipedia. It says they use the term Ousia in defining God as one genius of Ousia, while being three distinct species of hypostasis, the Father, Son, and the Holy Spirit. So God is Ousia. He's all things. And when you are in the flesh and spirit, that's why you embody the nomenon of God, because you are the Father, Son, and the Holy and the Holy Spirit. You're the flesh, the blood, and then the combined. And so the Trinity in Christianity comes from the three states flesh, spirit, and then together. So, but the distinction is that now that's the orthodoxy, okay? In the Eastern Christian tenets, which is the Roman tenets, it says all that subsists by itself and which has not its being in another. Okay, that's very important, because in their Eastern Christendom, which is the Roman Catholic civil law tenets, when you say I am in the hypostatic Trinity, when I am the man enlightened in living flesh, you are also saying in their law that you are not of another, particularly them. Because, like, for example, if I were to go in and say I'm pro per, they're going to rewrite it as pro se. Pro se is an abbreviation for pro secum, which means with them. Now, you can't be pro secum with them and then say I am of the Trinity and of substance that is not of any other self. Okay, so when you say I'm propria persona and they say pro se, you say no, I'm not with them, I'm not with you, I am essence of self, and I am in proper person, embodying living flesh. I am not of any other. I am not of any of you, which is what Yeshua said. I am a subsistence of self. So that's where when I say in propria personam is actually pursuant to our law. It's just they have the state of, they're the mask of state. So that prosecuting attorney is walking into the all capital state of, okay, and they put you in the all capital thing, but they're not giving you the propria personam, state of selfdom. So, and in Roman law, what is given to the plaintiff must be given to the defendant and vice versa. So if the prosecuting attorney gets to walk in as a titled nobility person and say, I have the mask of state. Sorry, I didn't want to put that down yet. I didn't want to talk about it. I have the mask of state protecting me, and I have immunity, and blah, 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 and you have to prove I'm violating color of law and all this other stuff. He's given that immunity, but you are denied the immunity and equity of the mask of selfdom in propria personam, and that is a violation of the law. That's a violation of the grant of law that established, and that's how you know they are not operating in the law, regardless of what they are. Regardless of the fact that they already have admiralty on the land, they're not even operating within the grant of law that is defined by the Benedictine, which is what they call the American Admiralty and the Jurisdictional Practices by Erastus Benedict. They call it the Benedictine, as in like the Bible. And it was told to me that for many years this treatise on the jurisdiction and practices of the American Admiralty in the Benedictine was never taught to anybody, and that the only people who ever see the older editions of this are the high judges, and the high judges and such, and that they are required to read it and learn it, because that's what they're operating in, is American Admiralty. Now, to the specifics in law, I'm going to now talk about where the term personae and proper person, the mask of selfdom, is actually stated in Title 28, and then we'll work backwards. There are several locations where the term personae, personam, is mentioned, and the first one of that is, amazingly, under the jurisdictional immunities of foreign states in Chapter 97. That's section 1602 to 1611. Now, when it is first talked about is in 1605C. Now, 1605 pertains to seizures of foreign asset or assets of foreign states. And this whole section, you need to learn it. You need to read Title 28, section 1602 to 1611. You need to kind of understand that you are a foreign state. And when you read it and you assume you're the foreign state, you'll go through and see how you actually waive your jurisdictional immunity as a foreign state by doing certain things that you've been compelled to do that you didn't know meant anything one is operating in commerce. Okay, so but really you're not in commerce. Your instrument's in commerce. So you have to separate the instrument, the all capital man, the all capital straw man, from you. Okay, because you are in commerce. It is. But that law has not been evolved. This is all new stuff. So this is stuff we have to kind of put down and walk in the administrative processes in order to reconstitute the law. Now, they're not very happy about this, and they're very opposed to it, but it doesn't matter because this is the law, and it will happen. So, in the particular section that we're talking about, Section B of 1605B actually talks about what we are being subjected to, which is a foreign state shall not be immune, that's us, from a jurisdiction of the courts of the United States in any case in which a suit in admiralty is brought to enforce a maritime lien against a vessel or cargo of the foreign state. Now, that's kind of actually in violation of the law, because I'll bring some things here. And so they've kind of evolved it to undermine that you're not immune from seizures. Okay, which maritime lien is based upon a commercial activity of the foreign state. So if you're in commerce in the United States, they're saying that your vessel can be seized and it's not immune from seizure as long as you're doing commerce. So this is your vessel, this right here. So when you are a foreign state of being in personae, the living flesh, the soul in the vessel. So they're trying to separate the soul of the man from the vessel. And they are only operating and controlling your flesh, which they don't even really have jurisdiction over pursuant to the law. That's a whole other argument. So 1605B talks about the seizures of vessels when you're in commerce. That's how they're taking you under arrest. They're doing it with cars, they're doing it with kids, they're doing it with your flesh, because your flesh is the vessel of your soul. Where the term in persona comes from is under C, and it says, and in Section B, it talks about a thing. It says, it talks about how they can seize your cargo, and I can go on. It says, the notice of the suit's given delivery, blah, blah, blah. And if the vessel or cargo is arrested, how do you arrest cargo? Get it? That's the stoppage holding. But you are arrested as a vessel or cargo, because a child's kind of your cargo. It's the dinghy tied to the big boat. It's the property within the keel, within the bowels, you know. It comes from the bowels of the vessel, okay, the mother. So if the cargo is arrested pursuant to processes obtained on behalf of the party bringing the suit, the service of process, but if blah blah, but if the party bringing the suit shall be liable for any damages sustained by the foreign state as a result of the arrest, if the party bringing the suit had actual or constructive knowledge that the vessel or cargo of a foreign state was involved. Okay, so if they know you're foreign and try to pretend like you're not, they're in trouble. Okay, because that's constructive fraud. And that is how you bring them to suits in admiralty, because they know you're foreign to them. They know it. And they don't tell you that. And they lie to you. And they get you to surrender rights that you shouldn't surrender. So they know you're a foreign state to them. And they pretend like you aren't. And they lien your property and your vessels and your cargo. Okay? In maritime, there are auxiliary liens in admiralty suits. Now, where that comes into being is C. Such acts, if in constructive fraud, shall not preclude the plaintiff. Now, mind you, when you sue, if you're a defendant and you countersue or cross-claim or appeal through notice of appealability into the federal jurisdiction, you become the plaintiff, where once you were the defendant. That's the importance of counterclaims and cross-claims in demurrers. So, it says, the plaintiff in any proper case from seeking relief in personam. In personam. Okay. So, the term in personam is actually a standing of a foreign state to them. So if you're not in there saying, I'm in propria personam, you aren't foreign to them. You're not making the declaration and preserving the rights of being a foreign state to their private jurisdictional forms. So you have to understand these things. Stand under them. And in this section, there in 1603, there is a cross-reference to, I'll have to find it. It's section 1332. Here it is. It's under 1603 definitions B3. And it says a foreign state except, this is a foreign state except as used in section 1608 of this title. And that has to do service and answers. It's much easier to service them as a foreign state. You just have to send it to them in green card, return receipt, and you're done. The type of service with marshals and stuff, not required because they're foreign to you. So you can service them as foreign instruments just by mail. But you got to know. And you have to say, I'm serving this to you as a foreign, you know. So, and so in any case, I know I'm running through stuff, but I want to get these, and you guys can back learn some of the stuff. But the point being is, you're a foreign state in propria personam to everything. To the courts, to the state, to the county, to the United States, to the international law, to all bodies of state. You are foreign, and only of the constructs of the living flesh. Okay? That's all you are. You have to surrender that right by acts. And one of the ways you do that is by not knowing the definitions of what make you a foreign state and what makes you not a foreign state. And so it says, including political subdivisions of a foreign state or an agency of instrumentality. And then it goes on, it talks about what is an agent of instrumentality of a foreign state. Means an entity, any entity, and it says C, which is neither a citizen of the state of the United States, which you're not because you ain't a thing, because the United States citizen is a thing. It's a plenipotentiary instrument, negotiable instrument, surety between the Holy Roman Empire and the United States of America. Treaty of 1812 states it. I think second paragraph. So you're not a United States citizen as defined in section 1332C. Okay, now I'm going to go to 1332C. The significance of 1332C, again, 1332 in Title 28 talks about diversity of citizenship amount in controversy cost. Okay, so they're referring you back to what is the debt, these are diversity of citizenship claims is what that's telling you. So when you go into these lower courts, quote unquote, and you say, I'm this, they really don't have jurisdiction over you because lower state courts don't have jurisdiction in diversity of claims. Those are all federal cases in admiralty. So when you say I'm in propria personam, you're already saying this is a diversity of citizenship claim, which means where you come from, your state's different than my state. And when they use the term citizenship, you're talking about the all capital. They're not talking about you. You're not a citizen. The all capital straw man is the United States citizen. So C says, for the purposes of this section 1441 of this title, that's another cross reference, this is what is a United States citizen. By definition, Title 28. United States citizen is, okay? Because they're talking about the diversity of citizenships of citizens, and it talks about the district courts shall have original jurisdiction in all civil actions. As again, when you profess to have in propria personam and you're an international, only the district courts or above have jurisdiction. So that already throws them outside of territorial jurisdiction. So that's why when you go and you challenge territorial jurisdiction, they either have to throw it away or their prosecuting attorney has to take it to the feds. Literally, that's the law. So that's why the territorial jurisdiction challenges of demur and saying, where do you get your jurisdiction to call me in here as a man, blah, blah. That's where all this significance happens, because when you do that, you automatically throw the claim into, quote, diversity of citizenship claims, which are under the jurisdiction of the district courts of the United States. Okay. Not the United States district courts. That's another point. So the de jure district courts of the United States, which is the seat, and then the corporations, all capital United States district courts are sitting in them. That's the attornment. So they've made a distinction between the seat, the United States district courts, or the district courts of the United States, which is what the word is in the grant, and then they flip it and call it the United States district courts in the corporate all capital bank that's sitting there. Okay. So back to C, sorry. So for the purpose of the section, a corporation shall be deemed to be a citizen of any state by which it has been incorporated, and of the state where it has been principal place of business, except that in any direct action against the insurer, of a policy or contract of liability, surety, whether incorporated or unincorporated, to which action the insured is not joined as a party defendant. Such insurer shall be deemed a citizen of the state of which the insured is a citizen. Okay, so you're deemed because you're the actual executor of the surety, even though you're not party to the action. Since that's an instrument of the United States that has been cooed, you are attached to it and seen to be in their jurisdiction. You have to separate. Okay. So that was one. The other part is this. 2. So it's 1332C2. The legal representative. This is the definition of a citizen. Okay. The legal representative of an estate of a decedent, the all capital trust name, shall be deemed to be a citizen only of the same state as the decedent. Okay, well, they created it in Rome. Okay, it's a creation of the county, but it's cured in the District of Columbia, and then it's kind of held and being used right now by Rome. Okay, so it says, and the legal representative of an infant or incompetent shall be deemed to be a citizen only of the same state as the infant or the incompetent. Well, in law, if you are an infant or an incompetent and you have a legal representative, you are of the same citizenship. Okay, that's fine and dandy when we all thought we were American citizens. But if you are an attorney, you are not a citizen of this country. You are foreign. So the way they're pulling infants and incompetent wards, which is what you're deemed insane, into the Roman civil jurisdiction is by applying and assigning you legal representation. So that's why every time you take legal representation of an esquire and allow it to be appointed for you and accept it and blah, 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 why you are then deemed under their jurisdiction of Roman civil form, because pursuant to statutes, you're the same citizenship as your legal representative. And that is where they lie the term in fictio, where you are presumed to be a citizen of Rome. And the word in fictio is a presumption put upon the defendant. This is definition. An assumption and supposition, presumption, put upon the defendant, which the defendant cannot overcome, such as you are a citizen of Rome when in fact you are not. Sound familiar? So that's why when I talk about you being in fictio, and the in fictio is clearly exposed, that you are being put in fictio by the definitions under the diversity of citizenship, section 1332 of Title 28, which is referenced in the foreign state immunity section. So, and you're deemed in fictio because you walk in, you're deemed incompetent, you're deemed dead, silent, lost, a soulless person with no enlightenment, and so you're given a legal representative as an agent, a foreign agent of Rome. And in that, as soon as you're given that legal representative, you become the same citizenship as that attorney, which is a Roman citizen. Okay, so your whole estate is moved into the jurisdiction of Rome. Get how they did it? So that's how they pulled you in to the international jurisdiction. And you have to stand there and pull yourself and your assets out of that assumption and supposition of in fictio and go, no, I don't have this esquire, I'm not taking legal representative, and I'm not waiving my foreign state immunity. I'm in Propria Persona, and I'm going to take my instrument that I am the lawful executor of, and I'm going to say, you're defrauding me, and I'm going to take it back and say, I will settle this because I'm removing you from your in fictio corruptions. That's basically what you're saying. So that is where just a portion of that is in there. And there's another section I need to find too. I may have to take a break here. Oh no, it's 1333. Now another important section of the whole diversity of claims is the section after 1332. And this will reference us back to the Judicial Act. 1333 of Title 28 talks about admiralty, maritime, and prize cases. Remember, I've told you, as a foreign state, you're being subjected to admiralty claims. in suits of admiralty, maritime auxiliary liens is what they're called, in suits of admiralty. And this 1333 talks about this particular jurisdiction. And this section is all under the district courts, the jurisdiction of the district court. So just the fact that I'm telling you all this, pursuant to their own Title 28, all these claims against you are supposed to be in the district courts. Okay, they're not, the states are not even allowed, and we'll talk about that, to even exercise in this jurisdiction. They're barred from prize law. States are barred from acts in rem. Okay, that is established. That is a limitation of our law. They have unlawfully brought the admiralty jurisdiction onto the land. Now, even when they do that, because I'll bring forth evidence about that in the Benedictine, that says that even when that's the case, the common law is supposed to answer the claim. Not theirs, not their edicts from the bench. So we are being lured and unlawfully by constructive fraud as foreign states to them, being pulled into their jurisdiction and having our state stolen as corporations and our infant insane wards of Rome. Okay, that's what we are. We're considered incompetent wards of Rome. Okay, sorry for that. So we're under admiralty, maritime, and prize cases. Okay, and the significance I want to talk about this is under revision notes of 1948. Always read the revision notes in the Title 28 and all of the civil, all of them. Always read. Don't just read the print at the front. You need to read all of the revisionary notes and the notes, the editor's notes, and all that stuff. Okay, in the revision notes of the 1948 Act, because it talks about the district court shall have original jurisdiction exclusive of the courts of the state of, 1, any case, civil case of admiralty or maritime jurisdiction, saving to suitors, in all cases, all other remedies to which they are otherwise entitled. Any prize brought to the United States or all proceedings from the condemnation of property taken as prize. You're the prize of the Roman agents when they seize your vessel and you're soulless and they make you a Roman citizen and they attach a maritime lien for fraudulent bankruptcies. If you just wrapped your head around that, you're there, because that's all they're doing. So the key word phrase here is savings to suitors. Okay, in all cases, all other remedies to which otherwise entitled. Now, there's a notation down the revision here. It says the saving to suitors clause in section 41.3 and 371 of Title 28 1940 edition was changed by substituting the words any other remedy to which he is otherwise entitled for the words the right of a common law remedy where the common law is competent to give it. Now, where did that term come from? Aha! Comes the Judicial Act of 1789. Okay? And the section that we're going to refer to when it comes to the saving to suitors clause and the right to common law remedy where common law is competent to give it, where they say and any other remedy. So they've removed the word common law in Title 28 by moving stuff around, but they have to reference it in their notes when they are torn the words they're using, and that's why you have to read the revision notes, because this phrase that I'm going to say to you is in their Bible that created their courts, their statutory courts. And it says this, Section 9, okay, the Judicial Act of 1789. And it be further enacted that the district court shall have exclusively of the courts of the several states cognizance of all crimes and offenses that shall be cognizable under the authority of the United States committed within their respective districts or upon the high seas. That's where you get that the district courts are territorial administrative courts. They're defined as that in Lucchini, I believe. And that's also in Title 28 too, where they define them and they tell you they're territorial jurisdictions. So, and that's where it comes from the Judicial Act. They're the territorial supervisory federal courts over the several states. Everything within those states, okay? It says, or the high seas. Let me go through this, read the whole sentence. It says, so within the respective districts or upon the high seas, okay? Because there's water within those districts, states with ports, where no other punishment than whipping not exceeding 30 stripes, or fine not exceeding $100, or a term of imprisonment not exceeding 6 months is to be inflicted, and shall also have exclusive original cognizance in all civil causes of admiralty and maritime jurisdiction, including all seizures under the laws in post, navigation, or trade in the United States. So again, affirmed in the district courts that they have cognizance when foreign states are operating in commerce within the territories that they're supervising, and that's us. Okay, so where the seizures are made on on waters which are navigable from seas by vessels of 10 or more tons burthen within the respective districts, as well as upon the high seas, saving to suitors in all cases the right of a common law remedy, where the common law is competent to give it, and shall also have exclusive original cognizance on all seizures on land and other waters than as and other waters than as aforesaid, made, and all suits for penalties and forfeitures in court under the laws of the United States. So they're telling you that if you are operating, if they're seizing you on the land, so they're talking about land seizures, and then they're also talking about water seizures. Okay, now highways are highwaves. That is a water term applied to the land so they can seize you in admiralty. Cop cars are called cruisers. Cruisers are the names of the little boats that the pirates used to send out with gunners to seize and cripple the big boats. Okay, that's why they're called cruisers. They're in their little cruiser boats as pirates, seizing you on the land on a water terminology so that they can apply admiralty law to you. And that's the fraud. This is all fraud. They're not allowed to do this. They're not allowed to do this. Not and then bring you into an admiralty court. Okay, and it goes on to say, and it shall have cognizance concurrent with the course of the several states or the circuit courts, as the case may be, of all causes where an alien sues for tort only in violation of the law of nations or a treaty of the United States. That tells you that the only courts that have jurisdiction in such cases where aliens are suing in violations of torts and law of nations is in the courts of the several states, the district courts, and the circuit court. So the Supreme Court doesn't have cognizance over these cases. Okay, the circuit court really is the highest. Now the Supreme Court has appellate cognizance, but not original cognizance. So that's where the term that they bring forth in 1333 when they're talking about savings to suitors, the right to a common law remedy where the common law is competent to give it, that is called the Savings to Suitors Clause of the Judicial Act. So you're affirmed the right to a common law remedy. Why are we getting it? Okay, why aren't we getting it? And I'm going to stop here because I want this to be a breaking point, because now I'm going to go in the next video. I'm going to talk about American Admiralty and be very specific in cases where I'm going to show you, because there's a lot of reading here, and I'm only going to go over like the first 5 times the word persona is mentioned in the Benedictine, and show you how they are actually violating their own law. They're violating Admiralty, they're violating American Admiralty, they're violating the grant, they're violating the statutes, they're violating a lot of things. And this is the inherent coup of the bar union, because they're not learned in the law and they're being told and educated unlawfully. I'm going to give them that benefit of that doubt. But, okay, I've taken jobs before where I didn't know everything as a chemist and stuff. I went and learned it. You have an obligation. You have a fiduciary duty. If your job is a judge in the courts of the United States, to learn the law. I don't care if they put a little disclaimer where we don't have to know the law, and so, we can say, oh, we weren't learning the law, we're not obligated to be, so if I made a mistake in the law, too bad, I can't be held accountable. Well, I'm going to tell you, I have heard on more than one occasion come out of their administrator's mouths where ignorance of the law is no excuse. And the first time that I have an ignorant administrator say something ignorant, I said, ignorance of the law is no excuse, and I'm still going to hold you to the law, and you're going to pay for it. I don't care what your little union tries to put aside that makes it so you have immunity from your criminal activities that are, I don't care if they're due to your lack of ignorance of the law or your knowingness with the intent to defraud me by the attornment, the twisting at law. And I'm going to end it there on this particular video, because the next one I'm going to be more specific about the Benedictine and the American Admiralty and in persona. So, namaste. Love you all very much.